Good morning, I'm Gary DeWaal, and this is Bridging the Week for June 5th to 9th, and today is June 12th, 2017. Last week, the United States Supreme Court ruled that the Securities and Exchange Commission cannot bring enforcement actions seeking disgorgement more than 5 years after alleged wrongful conduct has occurred. In 2013, the court previously precluded such untimely filings for SEC enforcement actions seeking civil penalties. The logic of these decisions should equally apply to enforcement actions brought by the Commodity Futures Trading Commission as well as other federal regulatory agencies that do not have their own distinct statute of limitations. In addition, the SEC brought an enforcement action against a broker-dealer not only for failing to file suspicious activity reports, but also for filing SARs without adequately explaining the rationale for such filings. Last week was full of important news developments in the US and UK. To help redirect our attention back to the financial services industry, let's get started. The United States Supreme Court ruled last week that the Securities and Exchange Commission may only commence enforcement actions seeking disgorgement within 5 years after the date of the alleged wrongdoing. The court grounded its decision on its prior determination in 2013 that enforcement actions brought by the SEC seeking civil penalties are also subject to a 5-year statute of limitations. According to the court, disgorgement is a form of civil penalty subject to an applicable catch-all federal statute of limitations that, quote, finds its roots in a law enacted nearly 2 centuries ago, end of quote. This law established a 5-year statute of limitations for, quote, an action, suit, or proceeding for the enforcement of any civil fine, penalty, or forfeiture, end of quote. In a unanimous ruling, the court found that SEC disgorgement is a form of penalty because it is imposed by courts as a result of violating public laws and for punitive purposes. In reaching this conclusion, the court rejected the SEC's view that disgorgement is remedial and not punitive. The court issued its decision in an appeal of a disgorgement award assessed against Charles Kokish. Mr. Kokish was accused by the SEC in 2009 of misappropriating $34.9 million in connection with 2 investment advisor firms he operated from 1995 to 2009. After a jury found that Mr. Kokish violated applicable law, the federal trial court assessed a disgorgement judgment of $34.9 million, of which $29.9 million was attributable to violations outside the limitations period. Although the U.S. Supreme Court in its Kokish decision and in 2013 explicitly addressed enforcement actions seeking civil penalties and disgorgement brought by the SEC, the logic of the decision should apply equally to enforcement actions brought by the Commodity Futures Trading Commission and other federal regulatory agencies that do not have their own distinct statute of limitations. The SEC also filed an enforcement action last week against Alpine Securities Corporation, a registered broker-dealer, in a federal court in New York City in connection with the firm's filing of allegedly untimely and inadequate suspicious activity reports. According to the SEC, from at least May 17, 2011 through December 31, 2015, Alpine failed to include in 1,950 SARs filed with the United States Treasury Department's Financial Crimes Enforcement Network material red flag information which it was required to report under its own compliance program that explained the rationale for the firm's filing. The SEC charged that Alpine also filed SARs in approximately 1,900 circumstances in connection with clients' deposit of a security, but not when such security was liquidated or the proceeds for such liquidations were transferred to the customer or a third party, quote, despite the fact that the subsequent liquidation and transfers were additional suspicious transactions, end of quote. Alpine mostly handled microcap stock transactions for other firms, alleged the SEC. The SEC seeks an injunction and fines, among other penalties, against Alpine. International FC Stone Financial Inc., a clearing member of the Chicago Mercantile Exchange, agreed to pay a fine of $40,000 to resolve charges that, during 2014, it failed to maintain complete audit trail data containing all mandatory fields as required for 5 years. According to CME Group rules, clearing members that guarantee connections to Globex are obligated to maintain a course to be maintained such audit trail data, except where the direct connect client is another clearing firm or an equity member firm. In such circumstances, subject to conditions, the other clearing member or equity member firm is required to maintain the audit trail data. Separately, Merrill Lynch Commodities agreed to pay a fine of $35,000 to the Chicago Board of Trade and disgorge profits of $124 for allegedly exceeding spot month position limits in soybean futures contracts for 1 day in February 2017. CBOT said this was the firm's third position limit violation in 5 months. Similarly, Davis and Massey agreed to pay a sanction of $30,000 to the Chicago Board of Trade and be suspended from trading all CME Group markets for 10 days for also violating spot month position limits for soybean oil futures contracts on 1 day in November 2016. And finally, the rollout of MiFID II will not be postponed again, said Stephen Mayhor, chair of the European Securities and Markets Authority, in a keynote address at the annual Futures Industry Association IDEX conference held last week in London, England. Currently, MiFID II is scheduled to come into effect on January 3, 2018. In his speech, Mr. Mayhor also expressed concern that in response to Brexit, some UK-based market participants may seek to relocate entities, activities, or functions into the European Union in order to maintain access to EU financial markets. When relocating, such entities may still maintain the bulk of their operation in the UK. However, Mr. Mayhor warned that, quote, outsourcing or delegation arrangements should not result in entities becoming letterbox entities, nor in creating obstacles to effective and efficient supervision. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Have a great week, and until the next edition of Bridging the Week, ciao.